Good morning. This is the regularly scheduled
This
collections.
meeting is being transcribed.
Thank you. We'll start again. Good
This
morning.
meeting is being recorded.
This is the regularly scheduled collection service board meeting. My name's Roxana Gamusio. I am the executive director. The first thing we will do to take care of business is to do roll call vote and assure that we have quorum. So when I read your name, board members, please go ahead and let me know you are here. Chairman Chip Hellman.
Here.
Thank you. Tony Zikovich.
Here.
Thank you. Jason Hill.
Here.
Thank you. Lori Hadwig. Here. Thank you. And Greg Zaworski is not with us, but we do have quorum in order to proceed. The meeting agenda and meeting information was posted to the board's website in August of 2022. Since then, we have also updated it with the current agenda on July the 5th, and so proper notice has been given. We will, at the end of the meeting, allow for public comment. If anyone is participating virtually or joins us, they'll be able to do so at the end, and so we'll make sure to not miss anyone from the public. Members, you've all been sent the agenda along with other documents to review before the meeting. If there are any changes to the agenda, I welcome those. Otherwise, I would need a motion to accept the agenda as we have it.
Motion.
Thank you. We have a motion by Chip Hellman. Do we have a second? Second. Thank you. And a second by Lori. All those in favor of accepting the agenda, please say aye.
Aye.
Any opposed? Hearing none, we will move forward with the agenda as it's presented. Also emailed to you and on your iPads is the record of the April board meeting minutes. If you could review those and let me know if you have any changes. Otherwise, I would need a motion to proceed.
I move we approve the minutes.
Thank you, Chip. We have a motion by Chip Hellman and a second by Lori Hadwig to accept as they are presented. All those in favor, please say aye.
Aye.
Any opposed, say no. Thank you. On your iPads, we are starting with page 7 is the director's piece, and the first item before you there is our budget as of April. We finished fiscal year 2022 with a total of $928,289 in reserve. The particular report you have in front of you is for April. So through April, we have a loss of $11,454, and then that leaves us at a balance of $916,835. We should, for our next meeting, have the closure of fiscal year 2023 to go over those numbers. I know we've had conversations about the numbers going down some, but at this point we have plenty of reserves, and so, yes, sir, Mr. Hill. So the year-to-date negative number that we've added is $11,454. It would be the very last column, and I think you can expand the iPad a little bit. That's what I just did to make sure I didn't miss it. So we will probably end, I would guess, with a negative for this particular year. Okay? Thank you so much for asking. The next item on your iPads are the 2024 meeting dates. I think those were emailed to you as well, and I'm happy to send them again if you need them. These are taking into account similar what we do now, starting at 9:30 in the morning on Wednesdays. If there are no changes to those dates, I would need a motion to proceed and reserve the rooms for those particular dates, and they will all be at 9:30.
Move we accept these dates and reserve the rooms.
We have a motion by Chip. Do we have a second? Second by Lori. All those in favor to move forward with those 4 meeting dates for 2024, please say aye.
Aye.
Good. Any opposed? Thank you. That takes care of the director's piece. I will turn the meeting over to our attorney, Hugh Cross, to proceed with the legal report.
Good morning. Yeah, you should have the copy of the legal report on your iPads, and as we usually do, just feel free to take your time reviewing the complaints, and if you have any questions, please let me know.
I ask you about number 5.
Yes, sir.
So if I read this correctly and understood it, the complaint is regarding the validation of the debt, and ultimately, furthermore, a cease communication from the consumer. But then, and the law is real specific about once you are asked to cease, you can communicate one more time on actions you intend to take. So the letter of warning seems perfect. My question, though, is when you get complaints regarding validation, do you actually review the document to make sure it complies with Regulation F from the? Are you?
I do. Yeah,
Okay.
I look at the document. If the documents aren't there, then that would be a problem. But generally, if the consumer or the debtor is saying there's no validation submitted, then I'll review what documentation is there. And oftentimes, the validation of debt letter will actually be attached to the complaint from the consumer. So I just look at that, and if it's in that, then I know there's not a violation. But other times, the respondent will respond to the complaint or the allegation that there was no validation of debt, and there will be documents attached to that. So I do look at the documents to see. Now, sometimes they'll say, I've contacted the consumer on X amount of times, like multiple times, and I don't necessarily request all of the different times, as long as the one time is within the 30 days and there's no violation, that's fine. But if they've contacted them multiple times after that or sent multiple letters after that, sometimes those are attached as well, but not always.
Do we ever get or often get complaints about overshadowing during the validation period?
No,
Okay.
I haven't gotten one.
Know what that is?
I don't.
Okay, so the validation notice gives the consumer 30 days with which to dispute the balance in writing. There's nothing either decided by a court or through the CFPB or the FTC that says we can't go ahead and, a collector can communicate with the consumer during that 30-day period, attempt to collect the money. Overshadowing is when you demand payment in full or payment of any kind during that validation period. So, because it would so I send you a notice, you receive it, it gives you 30 days in which to dispute the balance in writing, and then I call you and say you have to pay by Friday. I've overshadowed your rights because your legal rights are you have 30 days to dispute. I can call you and talk to you about the bill, see if you want to set up something to pay the account. And you can pay the account during the 30-day period, and we can have dialogue, but I just can't enforce a time deadline that would strip your rights away.
I haven't had one of those specifically that I recall. It's usually not a matter of a deadline. It's just the attempt period. Like, just is either outside the 30-day window or is inside the 30-day window, or it's multiple attempts from multiple agencies. I've seen that. Sometimes those are tricky because if it's, one agency attempts to collect and then they remove the account or get rid of the account and it's sold to someone else, and the second agency comes through and attempts to collect again, there's no guarantee that the former collection agency is communicating with the current collection agency. So sometimes I get those complaints, and
Right.
I mean, if there's a violation, then I'm looking for it, but sometimes but I haven't seen anything about overshadowing specifically, but I'll keep an eye out for that. I mean, I guess for me, I see that as overshadowing just kind of puts a name on the not respecting the dispute, the 30-day window. So,
Right.
Yeah, I could see. But if a respondent is attempting to collect after the the consumer has sent the dispute, then I would see that as a violation anyway.
Right.
Because they can communicate, but there's exceptions. I mean, they can't just call and chat with them or attempt to collect. I mean, they have to. There's specific exemptions in Tennessee law. One of them is to tell you what the collection agency intends to do, and how they intend to collect, to work out um, payment arrangements particularly. That's the only exemptions I'm aware of. I mean, if they're just calling to tell the consumer that they need to pay, that's an attempt to collect. So that would be a violation, in my opinion.
I don't know if the courts would rule in that way because pretty much everyone in the industry calls during the 30-day period. But what consumer attorneys are kind of focused on.
This complaint is about the cease of communication.
Okay. Yeah. Right.
Yeah.
Right.
So that's one. But the actual 30 days.
Yeah.
Yeah. I mean, it depends on what they're doing within the 30 days. But if the consumer disputes the debt,
yeah, no question.
Then then the respondent collection agency needs to send proof of the debt.
Yeah. Right. They have to stop actions and verify
so
the debt.
If I don't see that in the file, then that would be a problem.
Yeah.
Mm-hmm.
Well, I've looked through these and pretty much all of them except that one you're just closing. And
I will say, just since we're on this complaint, I consider doing because I may have forgotten, but there is a citation schedule for this board. Now, normally with this ceasing communication, there would be a $250 consent order, but I'm not, just based on what was submitted in the complaint and based on my communications and with the respondent, I'm not convinced that this was I think that the cease communication, so the consumer asked, I'm not going to pay the debt, please cease communication. So at that point, the collection agency should stop.
Right.
So my understanding from the respondent is that there was another attempt for to give additional information. You can contact us here, et cetera. But it wasn't an attempt to collect. But it's right on a fine line. So I want the letter of warning because of just based on the circumstances, I wasn't sure that it was a violation of the cease request, but it was close.
I think the letter of warning, I'm with that. First off, I think that's a good decision on your part. But the FDCPA is very specific about what that last communication can or can't do.
Right.
And it's not in the code that you can request more information. That's a violation. You can communicate one more time to tell the consumer what you intend to do with this account. So if you ask me to cease and we said, okay, we'll cease, we put it on hold, but we found he's gainfully employed with the state of Tennessee, so we're going to sue him. I could send you one last letter that says, Hugh, we're going to sue you, or Chip Hellman, we're going to sue you.
That's Tennessee law too.
Yeah.
So.
But asking for more information or something is not appropriate. I think you've done the right thing.
Okay.
I don't have any other questions. Do you guys have any questions about the legal report?
Do you think the letter of warning?
Tony, I'm sorry to interrupt you. Could you press it didn't pick
Is the letter of warning to the collection company, will that do anything? Will that make them stop, or what would that? I mean, is it?
I think in a outlier, if I got that letter from you and this was an isolated situation, it would cause me to read the letter and go to my operations people and just make sure. I would go look and say, why did we send another communication? And it puts me on notice that something may have gone wrong internally because we're not supposed to do that.
Okay.
And I think I would look. I may not spend a lot of time on it, but if you got repeated the same complaint for the same agency multiple times, then I think you got to slap some dollars on them.
Yeah, it's been over a decade since the prior violation. That's the other thing I was considering, but it was also the respondent did respond to the complaint and said that they sent this, sometimes it's really helpful when the respondent tells you what happened and writes it down so I can read through it and figure it out and maybe talk to somebody if I need to. And this respondent did that, so I have a pretty good understanding of what happened. and it seems like they understand that it shouldn't have happened, at least. But I was a little unclear on what the communication was until I got a copy of it, and then I kind of saw, okay, well,
What were they asking for in there?
just like you can, if you need further contact us here. Here's our information.
So they didn't want to drop. They want to give them one last avenue to figure out how to pay it, but that's not allowed.
Right, it's not one of the 3 exemptions. That was my
Right.
problem with it. So I could go either way. I think since the respondent responded to the complaint and they haven't had a violation in 13 years,
Right.
then it's probably an operational issue. But like I said, I just wanted to mention that before I finalize anything and see what y'all thought.
I don't think I would. If it's been 13 years, I don't think they seem to be good citizens, right? We don't know the names, but
Right.
they're not. We're not getting complaints on them over and over again. So that I feel like the letter of warning is probably enough for now.
Okay. And that's the thing. The citation schedule was drafted in 2018, but the board can vary from the citation schedule. That's why if I see something like that, I'll bring it up just in case.
I've seen times through the years of something really egregious where we, want to do something else, but these are pretty lame complaints, right? I mean, I shouldn't say that on record, but I mean,
They're
isn't-
kind of robotic,
yeah, this isn't calling me in the middle of the night asking me to pay my bills or anything that would really cause hardship on someone.
Right. And
I got a letter in the mail.
there's some. Well, the reason I started putting the actual rules in the summaries here is because the lines are so fine sometimes with these, like harassment. I mean, harassment is spelled out in the FDCPA and it's spelled out in Tennessee law and the rules. And if the behavior is not one of those, then it just, I mean, I can say that I'm being harassed by a collector, but if the attempt to collect is within the protocol and within the rules, then it's not a violation. So if the violation is for harassment, then I'll put the rule in there, and this is the rule. And I haven't seen, but I think 2 legal reports there was a harassment violation, maybe 3, where I ended up sending the CO for that just because of the repeated calls.
Yeah, right.
But I mean, that wasn't the case here. So
Just one last thing, and then I'm ready to approve the legal report. Unless, Jason, if you have questions. Okay. Or anyone, for that matter. But so then you notify the complainant that this is what you've done. Okay. And do they have a, what if they say, well, that's not what I was hoping here.
well, if they say that's not what I was hoping, I mean, there's not really. I mean, if it happened, that's the decision. There's really no appeals process.
Yeah, that's what I was going to ask.
Yeah, they're not for complaints. I mean, if it's a license revocation or something like that, that would be different. But for a complaint, I mean, it just goes through the standard operating procedure, and then once you're at the end of it, that's sort of the end. If it happens again, file a new complaint, and we can certainly look back at the prior complaint and see what happened there. But if it happened again, we opened a new complaint about it. I mean, at that point, it would certainly be a consent order.
Right.
Definitely.
Right. Okay. If there are no other questions, I'm going to move we approve the legal report, please.
Thank you. We have a second to approve the legal report as it has been presented.
Second.
Thank you, Jason. We have a motion by Chip, a second by Jason. All in favor, say aye.
Aye.
Any opposed? Wonderful. Hearing none, I will leave it with Hugh Cross on your, if you'll go ahead and put the presentation on the overhead screen. We have the presentation for the Sunshine Law that Hugh will do. You have it on your iPads, but if you'll follow what he's got here, then we'll be able to get through this standard piece. Thank you, sir.
You have this memorized?
Have the relevant rules and laws. Can you hear me? All right. I can hear myself. All right, you are my sunshine. This presentation is about the sunshine laws, which includes the Public Records Act and the Public Meetings Act. So we're going to go through that, and hopefully we can get through it thoroughly. If you have any questions along the way, I just ask that you hold them until the end. There'll be at the end of the presentation. We'll just go through any questions you may have, and if you don't have any, that's fine too. So this disclaimer here, I'm going to read it point by point, and it's no, it's basically just saying this is information we've compiled on our own. It's not necessarily legal advice, but it's just compilation of information. And if you have any questions, I can certainly give you specifics about anything that's contained herein. All right, so what is the Open Records Act? It's Section 10.7503 at SEC. Getting the ghost click here. What is included in open records for a board or commission? So you can see the nice little graph here. Defines what a public record is, what a state record is. These are documents, papers, letters, maps, and books, media, photographs, microfilms, films, and sound recordings, electronic data processing files and output, other materials regardless of physical form or characteristic. Now, I just want to say that on the right side, the main point on that chart is that it includes the documents that are created. So if it's a public record, if it's a state record, that would be subject to an open record and open record laws. But like the iPads, so the devices that the documents are displayed on, they don't count as a public record. Sometimes it doesn't generally matter, but sometimes it would matter if there's something on an iPad or a cell phone that's not necessarily a open record or a public record. Public Meetings Act, Section 8-44-101. This chart here explains the Public Meetings Act and answers the main questions that I've generally received. So what is the PMA? Essentially, meetings of government bodies should be held in the open in order to comply with the intent and spirit of the Sunshine Law. So it's mainly if you're going to conduct a business as a board or commission, it needs to be done in public. So I'll get to more of that later, but you also have to define what a meeting is and what it's not. So a meeting is a convening of a government body or a public body for which quorum is required to make a decision or to deliberate toward a decision on any matter. So that would be a great example. That would be this meeting here. We're here to decide on business, which is a legal report, and anything else that the board may have on the agenda. But notice is a big part of the PMA. The third chart there, notice, agenda, public presence, and minutes. And we'll go through those, but those are the main points. If you have a meeting, if you check those boxes, then that should be in compliance with the public meeting and public meeting laws. So what happens if the board violates the Public Meeting Act? Well, any decision that was made, any business would be nullified. I used this example in my last presentation, but if I'm conducting a rulemaking hearing, for example, I mean, that would be business. I mean, that's something that has to comply with the PMA. If something goes wrong, then whatever rules were decided on, they would be nullified, and we'd have to start back over from the beginning. So that's ultimately the consequence of being in violation of the PMA. Here's just a little bit more specific definition of a public meeting. So it's as I said before, it's the formation of public policy or decisions. So if the board is making either one of those, you have to do it as we're doing now in the open. Application, again, this is really just about if it's a public meeting, you're deciding formation of public policy or making a decision, it needs to be done in the open. PMA applies to every meeting of a board or commission. What is a meeting? This is the definition of a meeting: convening of a governing body of a public body for which quorum is required to make a decision or deliberate toward a decision on any matter. And this does include committee and sub meetings. This board does not have committee and sub meetings, so it's not applicable. But if this board ever decided to have committee or subcommittee, then it would. So what's not a meeting? Lunch breaks, restroom breaks, smoke breaks, meetings like that. Those are not public meetings in terms of the PMA. So, but if you're in a lunchroom, you see another board member, then generally you don't want to discuss any board business at that time. If you did, however, if you contacted me, the attorney, or Roxana, hey, I was in the lunch break and I saw so and so, and we discussed a policy. I was thinking probably not a good idea. You just tell me at the next meeting, we'll put it on the agenda, and it can be discussed, and it's resolved at that point. All right. Public Meetings Act exceptions. There's really the main exception is executive sessions. So an executive session is, this board hasn't had one. It's really, generally it's in, if this board is threatened with a lawsuit, then the board may want to have an executive session. And that's when one or more of the board members meet with the attorney in anticipation of litigation to sort of decide things. And at that point, it's really just questions related to the actual pending lawsuit. You wouldn't go in an executive session and just start talking about everything. It's really just specific to questions if the board is sued, so the litigation. And that's the main exception that the board should be aware of. Electronic attendance, this is a big one. So Tennessee law, it allows, so a board has to meet a quorum. If the quorum has to be met electronically, Section 844-108B1 and 2, they say that a meeting may proceed as normal with the other members participating by phone or electronic means. However, we have the policy here at the department that any member attending by electronic means of communication does not count towards the quorum. But as a policy, we require a physical in-presence requirement there. The application for the PMA, as I mentioned before, it's really just about being open to the public. There's two cases here that kind of go in depth about that. The main thing to know is the public has a right to attend and observe the meetings, but not necessarily participate in the meeting. I mean, if the comment is going to be disruptive or long, then the staff or the board has the authority to put to kind of direct the flow of the communication to make sure the communication is discussing an item on the agenda, and it's not disruptive to the flow of the rest of the meeting. So no filibusters or anything like that, essentially. So notice is a big part of the PMA, and there's a 3-prong test here. So if you're going to have adequate notice, the contents must reasonably describe the purpose of the meeting and the proposed action to be taken. The second prong, notice must be posted at a time sufficiently in advance of the actual meeting. The third prong, notice must be posted in a location where a member of the community could become aware of such notice. So, as you mentioned, there are 3 usual methods: internet, newspaper, and bill posting. I mean, this board, I don't know exactly when the agendas are posted, but they're well in advance of the board meeting, so there hasn't been an issue there with this board. Next slide is just basically the Attorney General opinion about notice, and it's an interesting opinion. I mentioned it at my last board meeting as well, but it's really about whether the public will be, is it somewhere the public will know or become aware that this meeting is occurring. Our usual practice is to put it on the department website. All right, just to reiterate here, the 3-prong test for adequate public notice. Whether public notice is adequate is an all the facts and circumstances analysis, and no single factor is dispositive. This case here, it's basically just saying that each prong is equally important, and that's it. All right, in a nutshell, the Public Meetings Act is designed to make sure all board business is conducted in a way accessible to the public. It applies to you, both as an individual member and collectively as a board. All gatherings of more than one member are meetings and are covered by the PMA, including regular, special, and emergency meetings, and including committee and subcommittee meetings. The only exception is the executive session, which is your opportunity to ask the board attorney questions in anticipation of litigation, as we discussed. For every meeting, you must give adequate public notice, content, location, time. As I mentioned before, if the board violates any law related to Public Meetings Act, whatever decision was made, policy was made, rules were made, would be just null and void. Oh, and costs could be assessed against the board as well. This NC Board of Dental Examiners, maybe way back when you first became board members, you remember in orientation this case was discussed. And it's a pretty interesting case. This is a federal Supreme Court case, and it's really all about unreasonable restraint of trade. You can see my little narrative there. I'll just read the whole thing. I think this part is important. I mean, it's useful, and if you ever get bored, like on the plane ride coming up, you can you can pull up this case. But it's pretty important that the board does not make public policy or decisions that would unreasonably restrain the trade of others in an active market. So the board members in this case, essentially, the Supreme Court said board members may not be subject to immunity for their actions on the board. During this case, the North Carolina board made a decision preventing non-dentists from providing teeth whitening services. The Supreme Court held that the board's actions were not entitled to certain Federal Trade Commission's antitrust immunities. The court determined that a non-sovereign actor, the board, controlled by active market participants, the board members who participated in the regulated profession, these board members were all dentists, and they were saying that non-dentists couldn't do this teeth whitening. So the board members who participated in the regulated profession enjoy state action immunity from federal antitrust liability regarding anti-competitive conduct only if the challenged restraint imposed by the non-sovereign actor is one clearly articulated and firmly expressed as state policy, and two, that the policy is actively supervised by the state. So Tennessee responded by the court's ruling enacting TCA 4-4-126 to protect board members by providing review of board actions that may constitute potentially unreasonable restraint of trade or anti-competitive actions. So it says here that deputy commissioner has a responsibility to actively oversee board meetings, and when we do, we have folks that watch the meetings just to see what was discussed and kind of aligns with the agenda and all of that to see if there's any issues, and if there is an issue, I get a call about it. Or Roxana does, or both. So there's people in place to watch, including us. It's not just, if the board is going in a direction with a discussion that seems to be touching on this, you'll know about it ahead of time. So I'll let you know. But if you have any questions, you can certainly contact me about that. So this goes into, let me flip back here. This next slide I'm going to go to kind of explains these little buzzwords in here. One of them is the supervising official, and that's what I just mentioned. We have the commissioner, deputy commissioner in this case. They have the duty to oversee the board and decisions and things that are to kind of see where the board is moving with discussions. And if there's an issue, I'll hear about it, as I said. This slide here is important because it explains sort of what happens if I'm notified that the board has made a decision or is creating a policy that some legally seems to be an unreasonable restraint of trade on the market. Then this is the action that would have to happen to at that point. So I get a phone call says, this decision seems to be in violation of unreasonable restraint of trade. So I have to provide notice to the board within 10 business days that the action is subject to further review. So obviously you know about that. Review the full evidentiary record regarding the action, and if necessary, supplement the evidentiary record or direct the regulatory board or other involved persons or entities to supplement the evidentiary record. Conduct a review of the substance of the action de novo and on the merits. In writing, either approve the action, remand the action, or veto the action. I am hard pressed to find a situation where this would occur with this board. We're pretty straightforward here. We even discussed the complaints. They don't really vary. So I don't see this happening, but if it does, this would be the process that would happen, and you would know about it ahead of time. If there's any questions, this is my contact information. Feel free to call me, email me anytime you'd like. But if you have any questions about this specifically, I'm happy to flip the slide back if you'd like. Otherwise, that's the end of the presentation.
Have questions? Anybody have questions?
Just one question.
All right, I have one question. So, what I heard you say is if people are always welcome to attend the meetings, say it, industry people. If they want to speak, we can allow them to speak, but we don't have to allow them to speak. Is that correct? Or we can cut them off.
This is an interesting piece because we've just had a change, but there's a new law that came through, and it's essentially this. It's this policy, but it's a little lighter. So the public has a right to attend and observe, but not necessarily speak. But there's a policy with this department that we're going to start implementing that will allow. So there's a sign-up sheet here. There's always a sign-up sheet here. Except we don't really. The main thing is we need to tell the public members. There's no member of the public present today, but if there were, even if there's not, we just need to make a statement. If anyone here in person or telephonically would like to make a statement, they can, and that's pretty much it. Now, if the comment is supposed to be something related to what's on the agenda. If it's not, then yes, in theory, the board would have the authority to say, well, it needs to be on the agenda to make. I think generally we're going to allow public comment if it occurs and just kind of direct the parameters at that point. And I think the main change now is that we just want to make sure, like I said, Roxanne and I's boards, we've all been on all our boards. We have a sign-in sheet up here for folks that want to speak. The only difference now is that we're making it clear ahead of time during the meeting. Sign-in sheet here with the ones to sign in, and that's it. Probably won't go through the parameters unless it's coming up as a problem. If it's something that's disruptive, then yeah, like I said, no filibusters or anything like that. I mean, if it's disruptive to the meeting, then that would be a parameter. If it's going on for long periods of time, that would be considered as a disruption as well. So, but generally, the board, you really wouldn't need to do anything if that were to occur. The attorney or the executive director would most likely be the ones to step in at that point.
Okay. There was a period of time years and years ago where these meetings were well attended by industry members, and people always wanted to talk. I may have been out in that audience a few times myself. Come to think of it, but depending on what the board had put on the agenda that they wanted to discuss, and so, but obviously that hasn't happened in a long time.
Yeah, I mean, I guess it's not so applicable for this board, but generally, just to make a member of the public can make a comment. I mean, we're just trying to make it clear that that's something that can happen. Now, if it's disruptive to the flow of the meeting, if it's not relevant to anything on the agenda, that could be a potential problem. But I mean, I think generally we're going to be pretty relaxed in terms of allowing the public comment. But it's mainly the PMA is really just about the attendance and the observation, not so much the comment period. But now with rulemaking hearing, that's a little different. I mean, rulemaking hearing, I've had one or two rulemaking hearings with this board, and at that point, I try to slow down and really allow for people to talk. I don't think this board has too many comments. Maybe one of the rulemaking hearings but also the board members comment as well. So I take that comment period pretty slow just to make sure I don't miss anything. And it's really important with some of the other boards as well. But that's the main thing. PMA is just saying public has a right to attend and observe, but if you're going to be disruptive, that's not really part of the act. So,
Okay. Any thoughts, questions, concerns? Thank you very much.
thank you.
Thank you all. So with that, we move on to our new business. Part of what Hugh just touched on, I kind of brought up at the roll call that we will be able to take public comments at the end. So that's part of this new law. We're going to make sure at the end to have some time, not only for those that are coming in person, but also participating remotely. So Dana's always on the Teams meeting, so she might see someone that's called in, so she would flag us to let us know someone's there for a comment. So again, at this point, we just open it up for any comments that are out there. So if anyone's on the public, Dana would stop us and we'd be able to get that done as well. So we'll make sure that's kind of new also going forward.
Okay.
The other last item that I've got before we conclude, board members, is I want to let everyone know that we have a sunset hearing for this program. The sunset process is normal. Programs have to be reviewed by our legislative branch to make sure that we have a reason to be here and we're given a certain amount of time before we go back before them. That hearing is on July 19th as just standard practice. Your chair, Chip Hellman's going to be attending with me. And so for the next meeting, we'll kind of update you on the extension that we've been given for how many years, any questions that came up, but it's a standard piece. So thank you, Chip, for coming.
Yeah, you're welcome.
Really appreciate that.
Sure.
I have nothing else. If members have questions, open it up to you all as well. If not, we can adjourn when you're ready.
I like that. I'll second that.
We have a motion by Lori to adjourn and a second by Chip, and I've got us at 10:12 a.m. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, we are finished. Bob, thank you for stopping our recording. Thank you very much, Dana, and